2014-37, State of Arkansas versus James Stone. Mr. Stone, you're appearing at this time for purposes of changing your plea pursuant to an agreement that's been worked out for you by your attorney, Mr. Russo. Is that correct?
Yes, sir.
Okay. And you've heard the state has already stated that based on the facts of the case, the possession of drug paraphernalia is being null pros. The court will accept that plea and thus null pros that. On the charges of possession of a controlled substance, marijuana, and possession of an instrument of a crime, both Class A misdemeanors, how do you now plead?
Guilty, Your Honor.
You're in this plea of guilty pursuant to an agreement that's been worked out for you, as I earlier referenced, by your attorney. Do you feel you thoroughly understand the terms of the agreement and the punishment you're to receive?
Yes, sir.
And are you satisfied with the advice and representation that Mr. Russo has provided you?
Yes, sir.
The court has the agreement in writing in this document I'm holding up called a plea statement. Have you read through and signed this plea statement?
Yes, sir.
And do you feel you understand what's set out in the plea statement?
Yes, sir.
You then understand the nature of the charges against you and the full range of penalties you're facing?
Yes, sir.
You understand the rights that you give up or surrender by entering this plea of guilty?
Yes, sir.
As you may have heard me go over with the previous person who was up here, when you plead guilty, you're giving up the right to a jury trial.
Yes,
You're
sir.
giving up your right to be represented by an attorney and assisted by that attorney throughout the trial process. You're giving up your right to confront the witnesses that would appear at trial and testify against you. And you're giving up the right to appeal. Do you understand these rights you're giving up?
Yes, sir.
And understanding what you're giving up, are you still willing to plead guilty?
Yes, sir.
Are you pleading guilty here today freely and voluntarily?
Yes, sir.
Has anybody in any form or fashion forced you into entering this plea?
No, sir.
As you plead guilty, do you acknowledge the truth of the accusations against you?
Yes, sir.
Do you acknowledge that back on or about the 27th day of January 2014 here in Baxter County that you had in your possession a quantity of marijuana?
Yes, sir.
And that you also had in your possession apparently some form of pipe or item for the use of marijuana.
Yes, sir.
Based on those statements, the court at this time formally accepts the defendant's plea of guilty, finding the defendant guilty of the offense of possession of marijuana and possession of an instrument of a crime, both Class A misdemeanors. And at this time, we'll so adjudge the defendant. In each case, the defendant is sentenced to 12 months of supervised probation, subject to the standard terms and conditions of probation of this court, a fine of $200, court costs in the amount of $200, a fine of $1,000, a drug crime assessment of $125, and a booking administration fee of $20 is imposed on each of those. All of those amounts will be due and payable as a term and condition of the probation, payable at a minimum rate of $100 per month beginning within 30 days of this date. The court will direct that the defendant will meet with the probation officer and get set up on probation. The court notes for the record that the defendant has signed the acknowledgement of the terms and conditions of probation, that he has read, understands, and will comply with the terms and conditions of probation. The court has signed those same written terms and conditions of probation, making them an order of the court that you are required to comply with.
Yes, sir.
You may be excused to meet with the probation officer at this time. Thank you. 2014-180, State of Arkansas versus Darren Norman. Mr. Norman appears on a charge of theft of property, a Class D felony, and is for arraignment today.
Your Honor, we've been in a plea of not guilty on behalf of Mr. Norman. Waive formal arraignment.
All right. This case appears on the Division 4 docket of this court. It will be sent down by written scheduling order for a trial date of January 12th, 2015. Pre-trial will be scheduled for November 29th of 2014, and a reappearance for status check on the status of discovery will be set for October 23rd of 2014. All those dates will be included in the scheduling order.
Your Honor,
Anything else to take up today?
Yes, Judge. Judge, there's some uncertainty for Mr. Norman on what his bond in this county currently is.
My information says $5,000.
I'm in jail for
What's the
bond.
jail record say?
I was looking to see what the origin of the uncertainty might be. If $5,000 is what it's been set at.
Can he decrease?
Your Honor, the person that came forward as his mother, Teresa Norman, that's standing behind the bench area. I would like to get, he's incarcerated in Fulton County. I'm not sure what the charges are, but I would ask for a reduction in his bond to approximately $2,500 under the condition that he would live with his parents, Mike and Teresa Norman, in the Salem area.
Judge, I think he's got charges pending in other counties. I don't know if any bond here is going to release him from incarceration.
This one will. This is the only one I would hold on. That's what,
Because that's our information at this point.
At this time, the court finds that the circumstances, the factual circumstances of this case and the information before the court, that the $5,000 bond is a reasonable